Hi everyone, let's talk about the judicial process and alternative dispute resolution techniques. In this lesson, we're going to describe how attorneys are compensated. We'll describe pretrial and trial processes and define key terms. We'll define class action lawsuit and examine what kinds of cases might qualify. We'll describe the appellate process and the possible results of an appeal, and we'll explain the use of arbitration and other methods of alternative dispute resolution. First things first, we'll look a little bit about how attorneys are compensated. There are a few ways. One is an hourly rate where attorneys are paid by the hour. They'll have billable hours for talking on the phone or in-person meetings or virtual meetings, and you would pay an hourly rate. This usually requires a retainer up front, which would be a set amount of money, call it $5,000 or so, they would bill against that $5,000. When you run out of that, then they would ask for more money. Another way is a flat fee. So this is common for more simple legal services like creating a will or a trust, forming a simple corporation or an LLC. They might just charge you an upfront flat fee, say $500 to create a will, something like that. Finally, we have the contingency fee arrangement, where this is an agreement with a client and an attorney, whereby the lawyer receives a percentage of the amount recovered by the winning or settling of a lawsuit. So if we win the lawsuit, the lawyer gets paid a percentage of the winnings. If we lose the lawsuit, the lawyer receives nothing. So a case to illustrate the contingency fee agreement is Gosel versus Boley International. This goes to the United States Court of Appeals for the 7th Circuit. So the facts of the case are that Cole Gosel is a 5-year-old child who is injured by a toy, which leads to a personal injury lawsuit for product liability. After 4 years of litigation, a settlement amount is finally reached for the amount of $687,500. The attorneys that the Gosels hired were hired on a contingency agreement, and the agreement was that they would get 1/3 of the settlement amount, which in this case amounted to $229,000, plus litigation expenses totaling almost $173,000. So this leaves the Gosels with $285,384, or 42% of the original settlement amount. The judge in the case thought that this was unfair, said that litigation expenses should be deducted first and then 1/3 of the net awarded to attorneys, which would result in the Gosels getting about $57,000 more dollars. The attorneys and their law firm appealed to the United States Court of Appeals for the 7th Circuit. So the issue here is, was the contingency fee agreement enforceable as it is written? The court decided yes. They said that contingency fee contracts play a vital role in the legal system, without which there would be disastrous consequences for people who are unable to pay up front. There was no indication the Gosels couldn't have negotiated the terms or shopped other law firms for a better deal. So they reversed the district court modification of the agreement and they enforced the original terms of the contingency fee agreement. A lot of people think that contingency fee awards to attorneys can be excessive, and you might be right. However, contingency fees are important because if I am a person who doesn't have means, I don't have the money to pay an attorney up front, a contingency agreement might be the only way that I can actually get justice by convincing an attorney to take my case, with the catch that if we win, they get a large percentage of that. If we lose, they don't get anything. So it's a big risk for a lawyer to take on. They're probably only going to accept cases that they actually think they can win. So it does give the people with less means at least some avenue and some access to the legal system. Before we get to court for a trial, we're going to enter the pre-trial litigation process. We define litigation as just the process of bringing, maintaining, and defending a lawsuit. There are a lot of processes involved. Bringing a court case is a highly complex process, and you are most likely going to need an attorney to help you navigate this process if you ever find yourself in this kind of position. You can try to represent yourself. It's just not a very good idea because, most of us just don't know enough about the legal system and how to do it. So involved in these pre-trial processes, we have pleadings, discovery, pre-trial motions, and settlement conference. We'll talk about each one of these a little bit more in depth. The pleadings are the initial paperwork filed with the court to initiate and respond to a lawsuit. The plaintiff is the person who files a complaint. The complaint is a document where a plaintiff it's a document that a plaintiff files with the court and serves on the defendant to start a lawsuit. So the complaint is going to name the parties to the lawsuit. They're going to allege the facts of the case and the laws that are violated, and they're going to add a prayer for relief, basically explaining why they think they're owed money or whatever they're asking for. Here's a picture of a sample complaint. You see at the top, it names the court, it names the plaintiff, and names the defendant. It goes on to describe, it first establishes that the plaintiff is a resident of the state of Ohio, establishing jurisdiction, saying the defendant is in the state of Washington, saying that there is diversity of citizenship between the parties, saying that the amount in controversy exceeds the sum of $75,000. So this is going to establish diversity of citizenship to try to get a case heard in federal court. So they're just establishing that up front. And then it goes on to explain what happened in the case and how a person was injured, and then name the amount of money they're asking for. So that's an example of a complaint. You know, if we're looking at smaller cases, and if we're looking at North Carolina specifically, you might find that a complaint is actually a fillable form, that you just download from a website. You can fill out this form and then submit it to the court. So this is a complaint for money owed, where you say somebody owes you money. You would name yourself and give your address here in the box for the plaintiff, give your telephone number, the county you live in. You'd name the defendant here under versus, check whether or not they're an individual person or a corporation. You can name additional defendants, and then you basically explain how much money they owe you, why you think they owe you that money, and then you just fill out the form and submit it with the court. So, it can take different forms depending on what you're asking for, where you're asking for it. So the pleadings. Continuing with the pleadings anyway, we have the complaint. The plaintiff has submitted the complaint to the court. The court is going to issue a summons to the defendant. It's going to say, here's the claim against you. Here's the complaint that the plaintiff filed. And then the defendant will have a chance to answer. They'll file saying they either admit or deny the allegations. They can include affirmative defenses. Affirmative defenses are just things that the law allows you as a defense to something. So if somebody is accusing me of assault, one affirmative defense to an assault claim could be that I was acting in self-defense. So I could say that they attacked me first and I was just acting in my own defense. If somebody's claiming that I defamed them in some way, an affirmative defense there could be that, well, what I said was actually true. And so truth would be an affirmative defense to a defamation claim. So this would be where they can establish those early defenses. If all the allegations are admitted, a judgment is entered against the defendant. Usually doesn't happen that way. If a defendant fails to file an answer, the court can issue a default judgment. Since they aren't there to defend themselves, the court will just believe the plaintiff and enter a judgment against the defendant. There can also be a cross complaint, which is a document filed by the defendant against the plaintiff to seek damages or some other remedy. So basically a counterclaim saying that the plaintiff has harmed the defendant in some way, and now the defendant wants money. A reply would be filed by the plaintiff as an answer to a cross complaint. An intervention, we're going through vocabulary here, guys. An intervention is an act of some outside party to join as a party to an existing lawsuit. So somebody might have a specific interest in what's going on in this lawsuit, or they may have also been harmed by this single act by a person, and they might want to intervene. A court might also, let's say if we have a lawsuit where several people are injured and we have multiple individual lawsuits, a court might act to consolidate courts. Say a person is driving and they end up hitting multiple people because they fell asleep at the wheel or something. If all these people are suing in individual lawsuits, a court might act to consolidate them, combining the cases together to hear one case rather than multiple smaller ones. If we have enough consolidation, and if there are a lot of parties involved, we would call that a class action lawsuit, which we'll look at a little bit later. A statute of limitations is a law. Each state has laws regarding statute of limitations, and there are some federal laws as well. But basically, a statute of limitations establishes the period during which a plaintiff must bring a lawsuit against the defendant. So after some injury or harm has happened, you have a certain amount of time to bring a lawsuit. Otherwise, you can no longer bring that claim if the statute of limitations has passed. A class action lawsuit. Okay, so when a group of plaintiffs with common claims collectively bring a lawsuit against a defendant, we will call this a class action. There are a lot of rules regarding what can be established as a class action lawsuit. A class has to be certified by a federal or state court. We have to establish sufficient commonality among the plaintiff's claims. All these people must have been injured in a similar way under similar circumstances by the same person in order for us to certify a class. The Class Action Fairness Act was a federal statute trying to rein in class action lawsuits that people thought might have been a little frivolous, but it requires certain class action lawsuits to be brought or transferred to federal courts rather than state courts. So an example we have of a class action, Tyson Foods versus, and I'm going to mess up that name, so I'm not even going to pronounce it. So the facts of the case are that employees at a Tyson Foods pork processing plant in Iowa allege that there's a Fair Labor Standards Act violation. They allege that Tyson Foods was not paying the employees for the time they spent putting on and taking off their protective gear. So they were being paid 40 hours a week for the actual labor, but they weren't being paid for the amount of time that they spent putting on and taking off that protective gear, for which they would have been eligible for overtime pay. So they file a class action lawsuit in U.S. District Court. The District Court certifies the class. We go to trial, and the jury awards the employees $2.9 million. Tyson appeals this case. They lose at the appellate court, and then they appeal again to the U.S. Supreme Court. The issue here is, should the class be certified? So the court said for a class to be certified, questions of law or fact held in common amongst all the plaintiffs must predominate over those affecting only individual members. So looking at the facts of the case, the court found that the employees worked in the same facility, they did similar work, they were paid under the same policy, so the class certification was upheld, and Tyson has to deal with the class action suit. If the class wasn't certified, it would just be up to individual members to sue on their own. If people band together, there's a lot more money on the line, so that's going to attract more attorneys who are willing to work harder on this case. So that's why it's attractive for the plaintiffs. There's a lot of criticism about class action lawsuits. Some people say the attorneys get too much and the plaintiffs actually don't get anything out of it. It all depends on the circumstances. I'm not going to try to convince you one way or the other. Discovery. This is the process during which the party engages in various activities to discover facts of the case from the other party and witnesses prior to trial. So we're trying to collect evidence. We're searching emails, we're searching text messages, we're searching transactions, any document related to the case. We're just trying to find as much information as we can. So we're discovering evidence to the best of our ability. In a modern age, a lot of people just aren't aware of what can count and what can be eligible for discovery. So even social media posts, text messages, there's all sorts of things that can be part of the discovery process that people might not have thought they would actually be held accountable for. So lesson here, be careful about what you post. The purpose here to prevent any surprises during trial by having all the information in front of us up front. It allows party to thoroughly prepare for a trial. It preserves evidence if you might think that a party might do something to destroy any evidence that might be helpful. It hopefully saves the court time and it promotes the settlement of cases. If we have all the information in front of us, it becomes a little bit more clear who has the stronger case, and maybe we can settle before it goes to trial. So some forms of discovery, we have a deposition, which is an oral testimony given by a deponent. So we call somebody in for a deposition. They sit down with attorneys. The attorneys ask a bunch of questions, and the deponent has to answer those questions. They are placed under oath to where they have the legal obligation to tell the truth during that deposition. The attorneys are kind of on a fishing expedition here to try to find out if they can get the deponent to say anything that would be incriminating to them, or something that would contradict what they had said earlier, or they might even use it later on in court. If they say something in court that would contradict what they said during the deposition. An interrogatory is a similar idea in that the person would answer questions, but the questions are submitted in written form, and then the person has time to write down their answers and then submit those. Production of documents, requesting copies of all relevant documents obtained by a party to a lawsuit from another party on the order of the court. So the court would order that a party turn over certain records. So these could be anything. It could be bank account statements. It could be phone records. Again, it could be text message history, voicemails. All sorts of things can count as discovery. The court also might order a physical or mental examination, especially if we're dealing with a personal injury claim or a claim for mental distress or something like that. The court might order that a professional party be examined by a medical professional to establish that the injuries are actually real. If we assume that the trial process is not a very pleasant experience, and it can take a long time, and it can cost a whole lot of money for both sides, it becomes clear to us, or at least easy to understand, that at least one of the parties is going to try to dispose of or get rid of this lawsuit right from the beginning to try to save a lot of time and money. So that's where pretrial motions can come into play. So there are a lot of different types of motions that can be made pretrial. I'll give you a couple of examples here. One is a motion to dismiss, where I'm basically just asking the court to throw this case out just from the get-go. It could be that the court doesn't have jurisdiction over the person or over the property. It could be that the venue is just all wrong. It could be that the person suing doesn't have standing to sue. It could be that we're asking the court to enforce an arbitration agreement that's part of a contract. So there's lots of different reasons people could motion to dismiss. These are just some examples. Another example of a pretrial motion is a motion for judgment on the pleadings. This is asking the court to make a decision based solely on the information in the pleadings. So the complaint and then the response. And we're not going to consider any facts outside of those pleadings. It's basically one party saying, hey, if you look at the pleadings, the information in there, there's not really any dispute of fact. So we think that you can make a decision based just on that information there. Similar to that is a motion for summary judgment, except for it opens up the possibility of outside facts. So basically, we're saying that there are no factual disputes, nothing that needs to be hashed out or found by a jury. The judge can just look at the pleadings. We can apply the proper law. The attorneys might go in and argue some outside facts to try to convince the judge one way or the other. But there you go, another way of trying to get a case decided and done with before we get too far, invest too much time and too much money into the whole process. So a case here, Wade versus Walmart stores, happened in Illinois in 2015. The basic idea was that Wade was going through, she had shopped at Walmart, she brought the shopping cart out to her car, unloaded it, she went to go put it back in the place where you put the carts in the parking lot, and on her way back to the car, she stepped in a pothole, suffering a broken foot. So she sues Walmart, saying that they were liable because it happened on their property and they should have maintained their parking lot better. So she sues for compensatory damages. Walmart moves for summary judgment, claiming they don't have any liability because the hole was an open and obvious danger. So they said in Illinois, if a property owner, if there is a danger or a hazard on their property, but if it's open and obvious enough to where a reasonable person would have seen it and could have avoided it, then the property owner wouldn't have liability there. So there's going to be a lot of argument regarding, whether it was open and obvious and trying to consider the perspective of a reasonable person. So we skip forward a little bit and just get to the decision. Basically, the issue was, should Walmart be granted summary judgment? The court said yes. They said that summary judgment is appropriate only when there is no genuine issue of material fact and the moving party is entitled to judgment as a matter of law. In looking at the facts of the case, they concluded that a reasonable person in Wade's position, who was exercising ordinary perception, intelligence, and judgment, would have avoided the open and obvious hazard. The trial court's decision was appealed, but it was then affirmed on appeal, so Walmart did not have liability. They were granted summary judgment. Another thing we can do pre-trial is have a settlement conference. This is where the attorneys will get together in the judge's chamber and start to identify the major issues involved in this dispute, trying to hash out what exactly we're going to be arguing. And during this, we can start, and during the whole process, pre-trial and during the trial, anytime before the actual decision, I guess even after the decision too, the parties could decide to settle. If they both agreed to it, they would sign a contract saying that we agree to this dollar amount or whatever is at play. And then we would be bound to that. And we would either not have to go to trial or we could stop the trial midway through if we have that settlement agreement. Looking at the trial itself, the Seventh Amendment of the U.S. Constitution guarantees the right to a jury trial in cases in federal court. The idea here would be to avoid biased judges. If we thought the judges were biased, we could bring in a jury of our peers who would help make decisions of fact in a case. The whole idea of making it more fair and more accessible to the general public. A jury trial is held upon the request of either party. When both parties waive their right to a jury, then the trial would occur without a jury, and then we would have the judge making the decisions. The judge sits as the trier of fact in non-jury trials. We define a trier of fact as being a jury in a jury trial or a judge when there's not a jury. It's basically whoever, we're going to have two sides to a story. One person says it happened this way. One person says it happened another way. Somebody's going to have to decide. We call that person the trier of fact. Broad overview of the phases of trial. Jury selection, moving into opening statements. The plaintiff establishes their case. The defendant gives their case. Then both parties can come in, offer rebuttals and rejoinders to counter what the opponents said. We have closing arguments. Then the judge will give the jury instructions. The jury will deliberate, and we have a verdict. If it's not a jury trial, then the judge would just go ahead and decide, and then they would enter that judgment. Looking at them a little bit more in depth, jury selection is the process of selecting from a big pool of prospective jurors who's going to act as the jury in this specific case. There's a lot involved in it. The old name for the process is voir dire. Most people will just say jury selection nowadays, but we sort of honor the old Latin terms that have been carried through hundreds and maybe even thousands of years. But you try to find people, depending on which side I'm on of the case. If I'm on the plaintiff's or the defendant's side, I'm going to try to find people who are either going to not be biased or who might be biased in my favor, basically trying to win this case. Both parties, when we get to trial, will make an opening statement. That says open statement, but I'm going to fix that right now. Opening statement. They'll make an opening statement establishing the main factual claims, the main legal issues at play. It's giving a brief summary of here's what happened, here's why you should decide in my favor. And then the other side gets to make the same thing. After the opening statements, we will move into the plaintiff's case. That's where they're going to establish that they suffered some type of injury and some type of justice has to happen. During this, The plaintiff is going to bear the burden of proof, whether we're talking about a criminal case or a civil case. In business law, we're usually talking about civil cases, although criminal cases certainly can happen. But the plaintiff bears the burden of proof. Since people are considered to be innocent until they're proven guilty, the plaintiff has to establish that there is either guilt in a criminal case or liability in a civil case. They do that through direct examination of witnesses, cross-examination of the other side's witnesses, and then redirect examination. We also introduce a lot of other evidence into the case. After the plaintiff establishes their case, then the defendant can go. The defendant can rebut the plaintiff's evidence, saying that all the things they said are wrong. Even if they were right, we still win. We can establish affirmative defenses. We can prove any allegations contained in the defendant's cross complaint. Then after the defendant establishes their case, and just keep in mind, this can go on for days, it can go on for weeks, months, depending on how complex the case is. This could either happen very quickly or take a very long time. After the defendant establishes their case, there is time for the rebuttal, where the plaintiff's attorney rebuts or argues against or counters the defendant's case. And a rejoinder would be when the defendant responds to the plaintiff's rebuttal. So these are fancier words for just, countering somebody else's argument. After all this, the attorneys both get their turn to make a closing statement, closing argument here. Summarize the case again, establishing why their side is right and why the judge or jury should decide in their favor, pointing out the weaknesses of the other side's case and why they should not win. After that, if we're in a jury trial, the judge will give instructions to the jury saying, if you decide this fact one way, then here's how the law should be applied. If you decide the fact another way, here's how the law should be applied. It might remind them of the burden of proof. The burden of proof in a criminal case is going to be that the plaintiff has to establish guilt beyond a reasonable doubt. If we're in a civil case, the burden of proof will be that we have to establish liability based on a preponderance of the evidence. It doesn't seem like it would make a big difference, but it's a huge difference. After instructions are given, the jury will go into deliberation. If it's not a jury trial, then the judge will go into deliberation. And then after deliberation, the jury comes back with a verdict. If they can arrive at one, sometimes they just can't. Sometimes they get deadlocked. But they basically have to decide unanimously that a person is either guilty or liable. In a civil case, the jury will decide whether a defendant is liable and assess damages, usually money damages. In a criminal case, the jury determines whether a defendant is guilty or innocent, and they may recommend penalties. So after the verdict, the judge will enter the judgment. This is the official decision of the court. In rare cases, the judge might enter their own decision, notwithstanding the verdict of the jury. This, again, very rare, but if they think that the jury was biased or if there was misconduct going on in the jury, the judge could have rendered their own decision. If the judge finds that the jury awarded too much money, or sometimes state law limits how much a person can actually get, and the jury might not know that, we could have a remittitor, where the judge reduces the amount of monetary damages that the jury can actually award. And then finally, we can have a written memorandum which sets forth the reasons why we arrived at this particular judgment. I won't spend too much time on this slide other than to say that, with the arrival of new technologies over the last 20 or so years, and especially necessitated by the current COVID crisis, if you're listening to, I'm recording this in May of 2020, so most of our businesses are locked down right now, and most courts aren't having people come up into the courtroom. So what's happening is a lot of internet conference meetings where people are just meeting virtually. This has been happening more and more. It's going to be accelerated greatly by what we're going through right now, by people being able to fill out online forms and submitting them online rather than having to go to the courthouse, with people entering testimony online without having to go to the courthouse. So we're going to see this happen more and more. Hopefully it'll make things faster and more efficient. Time will tell. If I don't agree with the decision that I get in court, I can appeal. So this is asking an appellate court to look at what the lower court did and hopefully overturn that decision that I don't like. Once it gets to appeal, we're not hearing new evidence. We're not calling new witnesses or anything like that. They're just going to review those court's documents and decide whether or not something needs to be changed. So in a civil case, either party can appeal the trial court's decision. Even if I win, I might think that I should have gotten more money. So I can even appeal even if I won. In a criminal case, only the defendant can appeal. An appellate court will reverse lower court decisions if they find an error of law. They can reverse a finding of fact if they think that a decision by a judge or jury is not supported by any evidence. It's rare for that to happen, but it can happen. They usually trust the trier of fact or the finder of fact to make that decision because they're the one that actually heard all the testimony. A little bit of vocabulary. The appellant is the person appealing a decision. The appellee is the person responding to an appeal. If it makes its way all the way up to the Supreme Court, we, give them different labels. We'll call them a petitioner and a respondent. I don't think you necessarily have to know that to live a full and happy life. If we look outside the court system, so if we assume that the court system can take a lot of time, it can cost a whole lot of money, I can start to look for ways to resolve disputes without having to go to court. And there are several of them. Some of them are way more common than others. So we'll talk about a few. The biggest ones are negotiation, arbitration, and mediation. There are other methods as well, but those are the dominant three. Negotiation is just a process of the parties sitting down to try to hash out a settlement agreement voluntarily. This hasn't been ordered by a court. We're just getting together saying, hey, we don't want to go to trial. It's going to cost a lot of time, a lot of money. You might lose and get nothing. So let's see if we can just work out some kind of agreement. If we can arrive at agreement, we sign the settlement agreement. That's a contract that both parties will be bound to. And then the matter is considered to be over and done with. Oftentimes, if you sign a settlement agreement, it will contain certain terms like this is done and you can't sue us anymore in court. It might have a non-disclosure clause in there where I can't talk about the case or talk about how much money I got out of it or anything like that, or I can't badmouth the business that harmed me. There will be a lot of parts to that. But the basic idea is that we come to an agreement and then we end the dispute right there. Arbitration is different. Arbitration looks almost like the trial process, but instead of a judge making a decision, we have an arbitrator, which is a neutral third party that we hire to hear evidence and testimony and decide the dispute. The rules are very relaxed for arbitration compared to the traditional trial process. It can move a lot faster, trying to get to a decision quicker. At least that's the idea. It's supposed to be faster and cheaper. Once an arbitration hearing is complete, the arbitrator makes a decision like a judge would and issues an award like a judge would. Arbitration can either be binding or non-binding. Binding arbitration means that once that arbitrator makes a decision, I don't have the option to appeal to the traditional court system. So if I get a bad decision in arbitration, I'm probably just going to be stuck with it and I have no other avenues for appeal. If the arbitration is non-binding, then I can appeal out into the court system. Arbitration clauses are becoming much more common in contracts nowadays. If you go back and look at the contract that you sign for, let's say when you buy your cell phone or when you're look at terms of service for using Facebook or Netflix or any of these services that you use all the time, what you're probably going to find out is all those contracts contain arbitration clauses saying that if you have a dispute with us, rather than going to the traditional court system, you have to bring us to arbitration and we can settle it in arbitration. So a little bit about arbitration procedure. A party gives notice to another party that we're going to seek arbitration. Then we select an arbitrator. We try to not select somebody who's going to be biased toward one party or against one party. That can be exceptionally difficult to find a person who's not biased, but at least that's what we try to do. After it's complete, the arbitrator reaches a decision and issues a reward. Several years ago, the federal government passed the Federal Arbitration Act, saying, giving a lot of weight behind arbitration, giving it a lot of legal weight. It provides for the enforcement of most arbitration agreements. So as long as I follow certain rules and the court doesn't find my agreement to be unconscionable, then they're probably going to enforce the arbitration agreement, which takes away my right to sue in the traditional court system. There's some controversy around whether or not arbitration should be legal in that way, or if people should have their right to go to sue in court taken away. Again, I'm not going to try to tell you how to think about that. It's just something to be aware of and to try to learn more about, to decide when you go and vote later on in life. This can be an issue that can be a big deal for you. I won't go over the entire facts of the case here. The basic idea was that there was a woman who had her daughter sign a power of attorney over her, giving the daughter the right to make legal decisions on her behalf, including the right to sign contracts. So the daughter signed a contract with a nursing facility, a nursing home, where the mother was going to stay. And the mother ended up dying later on. The daughter thought it was misconduct on the part of the nursing home. So she sues the nursing home in court. But we find out that the contract that she signed for the nursing home contained an arbitration clause. So there was a question whether or not did the power of attorney that the mom signed, giving the daughter the rights to sign contracts, does that include arbitration agreements? So there was some dispute as to whether or not an arbitration agreement would have the same weight as a contract. This goes all the way to the Supreme Court. The Supreme Court applied the Federal Arbitration Act, saying that arbitration agreements do have the same weight as any other kind of contract. So they enforced it, and they had to go to arbitration rather than the traditional trial process. Stepping away from arbitration, we have mediation, which is more relaxed, usually is not binding. There's not a person making a decision. What we do is call in a neutral third party, and that neutral third party acts as a mediator, like the name would suggest, to try to offer suggestions, to try to get the two parties to reach some type of settlement, acting as an intermediary. So they might listen to the opinions and the arguments of both sides. They might use their experience to give a little bit of information about who do they think might be more right or more wrong, or what a court might decide, and then start suggesting ways to settle the thing. The mediator doesn't have the power to make a decision or give an award. They just act as a go-between trying to reach a settlement. Last thing here, and I won't spend too much time on this again. We all know that the internet and the electronic age has changed about every facet of our life. Same thing with courts and alternative dispute resolution. So, this day and age again, and especially accelerated by the COVID crisis, now we can handle a lot of things electronically by using, whatever app you use to video conference with people. So that's all that this means, is just making sure we're aware of how things work in the digital age. That's it for this lesson. I hope you guys have a great day.